Hi, my name is Curtis Morrison. I'm an attorney with Ready Go Law. We do a lot of mandamus and unreasonable delay lawsuits. There's this new trend where AI and ChatGPT have enabled visa applicants to sometimes try to do these mandamus lawsuits themselves. There's a Latin term for this when you don't have an attorney. It's called pro se, Prose. I love it to the extent that it makes litigation more affordable, and that's important for immigrant families who are struggling a lot of times. In fact, our law firm tries to keep our prices as affordable as possible because we have that concern. And sometimes we even offer group lawsuits when we can to help democratize access to litigation. It is an important value that we have. But things can go wrong if you go to do things on your own and you don't know the law. And I just want you to be aware of one of the things that can go wrong. Okay? Let's jump in. So there's a judge, James L. Robart, and he just issued an order based on a mandamus lawsuit that was filed in October that is different than the order that he issued on a similar mandamus lawsuit that was filed in May. Okay? The difference, the case in May is on your left, and it was pro se. It was filed without an attorney. The case on the right was filed with an attorney. In fact, a great attorney, Jennifer Nimmer, one of my colleagues who has been doing this a long time. She's an expert. You can trust her. Okay, so here's the difference between the order on the left and the order on the right. See, I've put in the find box the word duty. In the first order, Judge Robart found that the court agrees that the plaintiff has not identified a mandatory non-discretionary duty that defendants failed to perform. Okay, that's not good. And then there is no dispute that defendants performed their duty to issue or refuse a visa. Basically, here they only got a 221G refusal, but the judge says they've performed their duty already. Also, the judge says that they conclude that the plaintiff has failed to state a claim for relief, and as a result, transfer would not even be in the interest. And because the court concludes that the plaintiff failed to identify a mandatory duty defendants have failed to perform, the court doesn't even address the unreasonable delay argument. In other words, the court didn't even look to whether or not the delay was reasonable or not. Okay? But we go to the order on the right where Ms. Nimmer represented the plaintiffs, and we see a different situation. We see the same judge find defendants have not yet performed their mandatory duty. Okay? In some, plaintiffs have alleged sufficient factual matter to allow the court to reasonably infer that defendants have a clear, certain, and mandatory duty to adjudicate the plaintiff's immigrant visa application, and that defendants have not yet fulfilled that duty. So what's going on here? Same judge finds in one case that there is no duty after a 221G refusal, and then in another case finds that there is a duty until there's a final decision. The difference is, in the second case, they used a lawyer and they used a good lawyer. Okay? So just keep that in mind, that while ChatGPT and AI is great, sometimes they're no substitute for a really good professional lawyer. Okay? Be careful out there. Thank you for watching this video.